Be seated. We'll hear argument in 22-256, Brown versus the City of Houston.
Please the court. Mr. Biles will present arguments for the appellants. Appellants have reserved 5 minutes for rebuttal.
May it please the court. Donald Biles on behalf of Alfred Dwayne Brown, plaintiff and appellant in this case. Despite the amount of briefing, this case at the end of the day hinges on the meaning of 5 words. May not bring any action. Those 5 words are why we're here today on a certified question from the U.S. Court of Appeals for the Fifth Circuit. This involves the Tim Cole Act, Section 103, 1.53b, which is where those words are found. And those words are crystal clear. We know that because in this state, the Supreme Court has said repeatedly that the first thing that we do when we're trying to define words is we turn to the dictionary. And if we turn to the dictionary, we turn to the Black's Law Dictionary in particular, we have the answer. To bring an action means to commence a lawsuit. But we don't have to rely just on Black's Law Dictionary. We have the Court of Appeals from Austin, who in a case with the similar language, different statute, similar language, decided exactly what we're arguing here today, which is that may not bring an action, or bring an action refers to the commencement of a lawsuit, does not refer to maintaining a lawsuit. That court took the time to go through several statutes that the legislature has passed that use bring an action, bring and maintain an action, and maintain. And lo and behold, each one of those, the court goes through and explains that they use bring an action when they mean commence an action. They use bring and maintain an action when they mean bring and maintain an action. And they use maintain an action when they mean maintain an action. Those words are also the subject of a series of cases throughout our jurisprudence over 100 years. As we cite a case, our opposition says those cases are not similar. With all respect, I disagree. The employment cases are the similar context. The question is, in those employment cases, was whether or not the filing of an action by the federal government meant that the same language, you may not bring an action when the federal government files an action, but that meant that your prior filed action had to go away, or whether you got to continue it. And the U.S. Supreme Court and the 7th Circuit, the 6th Circuit, I think it is, all go through that analysis and all say that the answer is that no, the plaintiff may continue their action. That the federal government, the Equal Employment EEOC, decided to bring an action after the fact doesn't now prevent the action that was prior filed.
The legislature also sometimes uses the word initiate, including in this particular, in other statutes in this particular context. Should we give bring a different meaning than initiate?
It could be. I would generally say no, but to be clear, I did use commence for reason, right? Because we see it in the Cerna case that our opposition cites. In the state of Texas, filing a lawsuit doesn't commence the lawsuit under our law, right? It's filing plus service equals commencement. So I would say initiate, commence, bring are all the same, but there's a possibility that initiate somehow might mean just the filing.
If they're the same, why would the legislature use 2 different words for those?
Well, I don't. There are. Well, I think there are synonyms. You can use sometimes we'll find whatever. I don't know, but that you have multiple
but typically,
words.
if they use different words, the presumption is that they mean different things unless proven otherwise.
If that's in the same statute, yes, but that I write one brief and say, I write one brief and I say somebody brought something, and another one I say they initiated it. It doesn't mean I'm not using it to have the exact same meaning. The dictionary, I mean, they're just using the words that in fact mean what they say. When they want to use maintain, they have.
Maybe one point of common ground, if I understand what you're arguing, is that your client's receipt of the Tim Cole compensation constituted a statutory settlement that prevents him from bringing a new lawsuit. So we're not talking for the moment about the pre-existing one, but you would agree that the acceptance of the funds would preclude him from bringing a new suit?
Absolutely.
Okay. What does that settlement do? Because wouldn't res judicata already foreclose such a thing?
I guess I'm not following you because I wouldn't say it's a settlement. It's a payment that they're obligated to make under the administrative code after we mandamus.
His acceptance of it, I thought you just agreed. Are you, you can,
I agree.
you're free, feel free to withdraw your agreement, but I thought you agreed that that was his, by accepting that that was a settlement that he accepted to not bring a new suit.
I guess I disagree with the word settlement. I agree that if in fact you accept the money, you may not bring a new suit. So I agree with the ultimate conclusion. I don't really agree that it's a settlement, but I do absolutely agree that if you accept the money, you may not bring an action, a new action. Yes,
All right,
I
okay.
completely
So the
agree with
reason,
that.
so you say it's not a settlement, and that answers the res judicata point, that it would not have res judicata consequences?
Well, I don't understand the res judicata because the statute, the administrative process is not meant to establish damages. It's not meant to decide constitutional rights. It's not meant to decide any of the issues that are present in a 1983 action. It's automatic. It's supposed to be automatic. And it applies to people whose constitutional rights weren't violated at all. Because, for example, my client, unfortunately, it's alleged, was wrongfully prosecuted and by folks who darn well knew that he was innocent and had it. However, there are plenty of people who, under the Tim Cole Act, that's not true of. They simply, there was a mistake. The DNA later found proves that they got the wrong person. Well, that's a different case, but that's why res judicata, we're not getting to, in accepting an administrative remedy, we're not getting to the underlying issues in our 1983 action.
Well, there's no question that I think that suit could have been brought under either, but you're saying that because, under the Federal Act or the Tim Cole Act, but you're saying that because of the word bring, that while it couldn't be brought once that compensation is received and put in there wherever, but that because it had already been filed, that whole principle doesn't apply because of the word bring?
Well, we can't, there was a point like in Oakley where you could file an action under the Tim Cole Act. That's no longer the case. You simply file an application. But I guess I'm not following you. Because our point is that we brought a case at a time in which Ms. Brown had not been found actually innocent. That lawsuit proceeded for 3 years. And as a result of that lawsuit, Mr. Brown was eventually found to be not guilty because the email that is part of the mandamus action, I think this court is familiar with, was produced to us in discovery. After it was produced to us in discovery, there was an investigation. That investigative report refers to the fact that that email was produced to us. That's what began this whole path. So I guess I'm not following.
I'm just trying to get at the point that I think that you agree that once that money was accepted and put into his possession, that he could not bring a suit but under the Federal Act, but that because it had already been filed, he could continue it, right?
Yes.
And
Sorry.
so the theory of why it couldn't be brought would seem to apply, right?
The theory
Of why, once accepting those proceeds, he could not continue with the federal suit.
No, I don't agree that he can't continue with the federal
Well,
suit.
I mean, it couldn't have been filed in the first place, I mean, once that's happened, but it could continue, and what would be the distinction there, looking at this wording within the context of the entire statute?
Sure. In the context of the entire statute, our opposition presupposes all sorts of reasons for why the statute exists, which there's not evidence of it. It's fine. That's their argument. But at the end of the day, the statute exists to compensate those who are wrongfully imprisoned.
Does
Does
the word does the word bring connote a temporal element like take or carry that's different than words like initiate or commence?
Can I ask that a slightly different way? Sure. Isn't it, in common ordinary meaning, isn't it correct to say that Mr. Brown is currently bringing a lawsuit against the state? Whereas you wouldn't be able to say Mr. Brown is currently initiating a lawsuit against the state.
I suppose one could. I wouldn't suggest to people they not
Well, but just
so
common
say.
ordinary meaning, it wouldn't be unusual to say, oh yeah, I'm bringing a lawsuit against the state. Something I filed, a year ago, and we're in
Yes,
the middle
but-
of discovery, but yeah, I'm bringing a lawsuit.
But the reason why you're bringing it is because you commenced it, right? You couldn't say that after the case was over. You couldn't say that the fact that you file a motion, as they say, doesn't mean you're bringing the lawsuit. The fact that you're bringing the lawsuit because you filed it and you served it. What goes on after that is no longer bringing it. It is true that it still exists. It is still in existence, but it's not correct to say that you're bringing it. It's that you've commenced it, you're involved in litigation, whatever you want to say. But on this issue, as our opponent puts in their first line of their argument, they change the wording. They take out the may not bring, replace it with relinquish. Boom, you got it. That would have worked. You could have actually written it that way.
I recognize your textual argument, take it very, very seriously. But I just want to make clear, is there any reason you think that the legislature might purposefully have meant the version as you're describing it, as opposed to, well, sorry, they used the wrong word and we're going to enforce the law as written? Which one is it?
I actually believe there's several reasons. And then two, I think this court has already said a couple of times that even if we know or believe that they made a mistake, we're not going to
No,
change
I
it.
know
We're
that
gonna-
part. What I want to make sure, though, is do you think that there are reasons
Yes.
for us to think that they didn't make a mistake, but they actually intended the reading that you're advancing?
Yes, I do.
Okay, tell me what that
One of those is Mr. Brown. And under the case law, right, it doesn't even have to be specific to Mr. Brown. It could be any rational basis the legislature might do this. So in Mr. Brown's case, he was wrongfully prosecuted. And if he doesn't file, if you're wrongfully prosecuted, right? Well, let's back up. In Ray Smith. In Ray Smith, this court, just as Lehrman pointed out, that the legislature could go back and fix it, but there is an issue with actual innocence, because most people who've been wrongfully convicted, given the chance to get out, will say yes to a dismissal that just says dismiss, doesn't find them actually innocent. Actually, innocence takes a whole lot of effort. So for all those people who are put in not because the DNA was wrong, and they find out, sure, you're going to get an actual innocent finding there. But if the prosecutors intentionally prosecuted somebody unlawfully, intentionally, the only way for Mr. Brown or any other person, similarly situated person, to figure that out is to file a lawsuit. How else are they going to get the deposition? How else are they going to get the email? It's the litigation. So I think it's very rational to say, listen, what we're concerned about here is people who take the money and then turn around and sue. We don't like that. But in this case, they're not so much worried about people who need to sue in order to get there in the first place. Because otherwise, these folks, the people, in my opinion, who most deserve it, the people who were put in there intentionally, have no chance of ever getting there. That's certainly one reason. I think it's also true. I have a series of them, actually. Sorry,
Let me ask you something
Sure.
different before your time expires. We can certainly opine on the state law question of what it means, what this statute means when it talks about bring any action. But I wonder whether the way that the certified question is phrased, does the Tim Cole Act bar maintenance of a lawsuit? This is a Section 1983 lawsuit under it's a federal statute. It seems like in a way, the certified question is asking a federal law question of when state statutes can change your federal remedies.
So, the answer to our brief had two issues. We're here on one. You've just touched on the other one. The Fifth Circuit still has that issue. But I will use this to say that the issues in our opponent's briefs about immunity are off mark. They're irrelevant. The state, obviously, as they admit at one of the footnotes, the state can't grant immunity to a county or individuals or the city for 1983 violations. That's a federal law. They can't, so there's no grant of immunity from the federal law to this. That's why in the state of Washington, they have a very different regime, the same result, but they put in there that you must release, relinquish, extinguish, waive, sign a deal, blah, blah, blah. Because this is on appeal. But some law will say, the opponents will say in the Fifth Circuit, oh shit, sorry.
You can finish.
So sorry, I didn't notice. Some in the will say that as long as you have a relinquishment waiver, those things they can't. I would say they can't grant immunity though. So it matters for that reason too, how you set up the statute to get to the result that they're looking for.
I have one quick follow-up, Chief. You mentioned briefly that existed. We know it exists in the litigation. You did not advance the Supremacy Clause or the possibility that a state statute like this one that would have the purpose or effect of foreclosing Section 1983 litigation would be unconstitutional. You didn't advance a constitutional avoidance rationale to us for reading the statute in this particular way. Is there a reason for that?
Yes, in the sense that, well, I guess we advanced our arguments, and then it's fair enough. If we got into the ambiguity and all of the 311 factors, which I think don't apply, because we only get to all those factors, as this court has said, if it's ambiguous, one of those would have been constitutional issues, and then I would have told you, if we get that far, yes. But I think we win straight up on textualism and separation of powers.
Any other questions? Thank you, Mr. Biles.
Thank you.
We'll hear from the respondents, or the appellees.
May it please the court, Ms. Martin and Mr. Hopkins will present arguments for the appellees. Mr. Lineberger will present arguments for the amicus. Ms. Martin will open with the first 7 minutes.
Good morning, and may it please the court. Less than 2 years ago, in Mr. Brown's own mandamus action, this court stated in footnote 60 that this provision of the Tim Cole Act, 103.153, presents an administrative process for settling wrongful imprisonment claims and reflects a balancing of policy choices.
How do you get around the plain language, bring an action?
I don't think we have to get around that language. Bring can mean to put forward, and it's bring any action. Bring means to put forward, to assert, to proffer. An action can mean more than just lawsuit. Action can mean cause of action, claim. If you are bringing any action, you are presenting any claim to any court. That can be the plain language, just as initiate suit.
Well, Mr. Brown's reply brief hits pretty hard on the idea that after all of this briefing, your side has not identified any statute that uses the word bring by itself like this, in which a court has held it to have the expansive and maintain. Is that right? Can you tell me which cases you think
So,
point the other way?
if I understand your question correctly, it may be a misnomer, because if there's not a case that says bring and maintain, that might be because the legislature says the other words for bring. It says initiate, to commence. If we can't find a similar statute that uses bring to mean maintain, it could be because, they're using the word maintain for maintain.
What about Walters versus Livingston and the Texas Religious Freedom Restoration Act? Which
Yeah.
says bring?
Yes, that is the use of bring an action in that context was in the context of a notice and opportunity to cure. And it makes sense for bring an action to commence a suit in that case because it's saying no later than 60 days prior to bringing an action, right? And it gives the defendant and the prospective defendant an opportunity to cure the defect before the action is brought. That is the context that is lacking here.
And I agree we can distinguish that and find good reasons for it. But what I don't see is the case on the other side in which affirmatively using bring means what you say it means. So he's got some like that one in which he says it means what I say it means. You can distinguish it. What do you have affirmatively to bring, shall we say, to us in which bring is used in the way that you need it to be used here?
The best I can tell you is if you look at the legislation, and we cited the session laws in our brief, this legislation itself implies bring means maintain, prosecute, assert, put forward, all of...
And I recognize all of that, but I'm just saying, is he wrong to say that we would be the first court and that this would be the first statute in which that context for just the word bring by itself carries this meaning? It might be. I mean, some case has to be first, but is this the first?
I couldn't find anything to the contrary. So I think it's fair to say this might be the first. But the most important thing we need to remember here is that we can't read bring in isolation. It has to be bring any action in the context of this balancing of policy choices that's within the greater statute as a whole.
And where does that point to the words in the statute that you're referring to? In terms of looking at this context.
Sure, and looking at the context, what we see is before 2001, there was no administrative remedy. It just didn't exist. You had, if you wanted compensation from the state of Texas, you had to bring a suit against the state of Texas.
But I mean the context within the words of the statute.
Within the context of the words of the statute, bring an action can mean maintain, it can mean include, because the statute was enacted to create a remedy that didn't exist before and expressly authorize people who had filed suits to pursue that remedy to avoid the litigation. And as this court said in just a couple of years ago, in 2020, when it decided Brown's own mandamus, the point of this statute, the manifest object of this statute, is to bring finality to litigation, bring an end to the expense and burdens of litigation for both the litigants as well as individuals who are employees of governmental units and these lesser governmental units. 103.153 was only brought into the legislation at the same time as this administrative remedy. If 103.153 was not meant to completely eliminate litigation against these governmental units or employees, then it wouldn't have been brought at the same time. This was a trade. The state made the administrative remedy more available to more claimants. It increased the compensation. It over the years has become more and more generous with tuition and life skills training, vocational training, child support. All of these things come at the cost. The state is being more generous, but the city of Houston and my other clients are receiving the benefit of that, which is finality and no further risk in litigation.
What do you say to Mr. Brown's point that there are some cases in which all of these benefits will be extended and it's perfectly fine to use the administrative process because, gosh, you know, mistakes were made, something happened, and we've discovered it, we've discovered the lab was bad, whatever, versus cases like this one in which the only reason he was able to get to that point was by initiating litigation that led to discovery that showed that this is not just a case where accidents happened, something made, but there were people who were doing things to put a citizen of Texas in prison when they knew that he was probably innocent. That doesn't seem like a different situation. Why would the statute have to distinguish between those two situations in that same way?
Well, and I don't think it has to.
Why wouldn't it, I guess?
Why wouldn't it? Because if he did initiate the suit, and then he did discover the evidence that led to being declared actually innocent. I see my time is up. May I finish?
You may finish.
Even if he was able to get that stuff through the discovery process, he ultimately did receive the benefit of his bargain, which is the Tim Cole Act funds. And once you get that receipt, as this court said, a conditional immunity arises in favor of other local governments and their employees.
Can I just
Yes.
follow up very quickly? Both sides agree that once he recovers under the act, he cannot then initiate a suit. The issue here is kind of in the middle, which is once he recovers under the act, can he maintain or continue a suit he brought before? Does the act say anything about what if he brings a suit and recovers in the lawsuit, settlement, or gets to trial quickly and gets a judgment? Does the act then prohibit him from seeking compensation under the act?
And that would be State versus Oakley. It's not in the statute itself, but State versus Oakley was, he received a settlement from the local government entities, and then the state tried to bar him from seeking Tim Cole Act funds under the Tim Cole Act, and this court said, that's not the way it works.
Any other questions? Thank you, counsel.
Thank you.
We'll hear from Harris County.
May it please the court. Good morning, Your Honors. I'm Seth Hopkins representing Harris County. On January 7th, 2021, Alfred Brown cashed a $980,000 check from the state of Texas. And in doing so, the state waived its immunity from liability in exchange for Mr. Brown waiving his claims against its political subdivisions and its employees. We're here today to ask the court to honor that agreement and answer the certified question in the affirmative. I'll address 3 points. First, the special rules of construction that apply to immunity statutes. Second, how the phrase "bring any action" means the ongoing act of litigation. And third, how Brown's interpretation of the act would lead to absurd results.
Should we limit our opinion to this question about what it means to bring any action? Or, as I read the certified question, we could get pretty deep into the federal preemption, the relationship between a state statute and a federal claim, and whether this is a settlement, and all those other issues that are floating around this question of what's the consequence of our construction of the word "bring." Do we get into the rest of that?
Your Honor, you can. The Fifth Circuit has expressly indicated that you can go as deep as you'd like to.
Are some of those federal law questions?
If you'd like to, though, we'd ask for the opportunity to brief the issue before the court made a decision, but certainly the Fifth Circuit had no restrictions on how the court could answer the question. We would like the opportunity to brief that, though.
The way this has been presented, should we limit our analysis to the word "bring"?
We would advocate that you limit the analysis to "bring" and let the Fifth Circuit deal with the Supremacy Clause. But if you want to go further, we're certainly happy to brief the issue. So the first thing I'd like to talk about
is there a difference in a situation where, a state party was just mistaken, there wasn't DNA evidence available at the time or whatever, as opposed to an intentional, plan to try to harm an individual by trying to put them in jail when they shouldn't be, and how that interrelates to the 1993 claim?
I don't believe the statute Tim Cole draws a distinction. It gives a choice. If you're actually innocent, you want to invoke the statute and take advantage of this settlement and avoid a trial, you can do that.
Wouldn't the use of the word "bring," though, potentially be a basis for drawing that very distinction? Someone who must bring the lawsuit in order to get the discovery because there's no possible way to get the administrative declaration without it, that is now grandfathered in, as it were, by the choice of the word "bring" in this statute.
Justice Young, I don't think so. And to answer your question, I'll also answer a question you had posed to my colleague when you asked about the question of what cases support your definition. And I'll cite 3 cases: the Cerna case, the Dynamic CRM case, and the Bowles case. All 3 reject Brown's...
What was the third one you said?
It's Bowles, that was cited by the state. I may be mispronouncing that. It may be Bowles. But all three reject Brown's narrow Black's Law Dictionary definition and hold that bringing any action includes the steps necessary to complete a lawsuit. And I'll go through each one very quickly. Cerna asked whether a suit was properly brought if it hadn't been served. The Fifth Circuit noted, quote, in Texas, bringing a suit is not synonymous with filing a pleading. That's because bringing a suit requires more than that. It's the ongoing act. Dynamic looked at a contract requiring that a claim be brought in state court. Defendants removed and argued that while the claim had to be brought in state court, it could be decided in federal court. The Fifth Circuit held bringing an action includes conveying, leading, carrying, or causing to come along, as Justice Bland pointed out when she was asking a question of my colleague. And finally, in the Bowles
Is there any reason for us, before you turn to the last case, to think that language in a private contract might be different than when a legislature uses that word?
No, Your Honor, for two reasons. The first reason is you interpret words are words, right? And if you're trying to divine the meaning of the legislature versus the meaning of private parties, the outcome should be the same, with the one caveat that this is a waiver of immunity, which should be strictly construed. And the second answer is, if you accept the premise that this is a statutory settlement, well, that would be decided under contract law. So we have some analogies there. So the last case, the Bowles case, held that, and this is probably the best case, even though it's an old case, it was interpreting a statute, a federal statute. The quote is, a suit for $50 includes everything from filing a complaint for $50 to recovering a judgment for $50. Once again, it's the ongoing act of litigation from beginning to end. So that's how we construct, and those are the three cases that we use, and that's what we advocate that the court find. But
So you mentioned that it's a settlement.
Correct.
And I wonder whether even reaching that and saying whether it ought to be conceptualized as a settlement is beyond the scope of just answering what it means to bring an action. Because if let's assume that you're right about what it means to bring an action. That doesn't necessarily dictate that we conceptualize this as a settlement or a waiver of all claims that might exist, as opposed to just a bar on the bringing of them, which then, and whether it's a knowing sort of settlement and waiver or just a state law bar on a federal claim, that might affect the federal law answer to whether he can actually move forward with this, because you might imagine that states can't just bar federal claims, but states could create regimes in which people can waive their federal claims, and the federal courts would enforce that waiver. And so the way that we talk about that seems to be very important.
well,
But also maybe a federal law question. I mean, how are the federal courts going to treat this in terms of whether they look at it as a waiver of a federal claim?
I would suggest to you, Your Honor, that the Fifth Circuit, if they believe there's a Supremacy Clause issue or a federal issue, they'll probably, no doubt, take that issue up. I think they're just looking for us to tell them, under Texas law, is this a statutory settlement? Is this something where Mr. Brown was giving up a claim?
My point is this a statutory settlement is a separate question from what does it mean to bring a claim?
I don't think so, because I believe that statutory, if you define bring as the ongoing process, and you understand this to be a statutory settlement, you can't continue with that lawsuit.
For it to be a settlement, though, wouldn't there have to be some indication from Mr. Brown that there was a knowing, voluntary, intelligent waiver of the particular claims? In other words, is this kind of a one-way door? And usually a settlement has mutual releases and statements about the scope of the settlement.
Well, but we see this all the time. Washington State, as my opposing counsel alluded to, has something similar. And certainly cashing a check is a knowing, voluntary understanding that you're taking the money, and there's got to be some quid pro quo. And there was a mandamus
Let's say there
action.
was clear precedent from the U.S. Supreme Court that state statutes cannot constrict your federal remedies. If that were the case, would it be fair to conceptualize his acceptance of Tim Cole Act money as a settlement of his federal claims when there's law out there that says the state statute cannot constrict your federal remedies? Let's imagine we're in that world. Can you say in that world that he has settled his federal claims by accepting the money?
I think we would want to brief that issue, but I think that if it is known, if it's understood that he is resolving his claims, certainly parties can settle anything. The state can settle on behalf of its political subdivisions and employees. Nothing prevents them from doing that, as long as it's understood that's what's happening.
If I've got a precedent that says the Tim Cole Act cannot constrict my 1983 remedies, and let's just hypothesize that that's federal law, even though probably not. If I know that that's the law, then in what sense am I abandoning my 1983 claim by taking that money?
I think that's hypothetical outside the scope of what we have here. In that hypothetical, again, we would want to research the Supremacy Clause issue, but I still think that I think the right of a party to contract, the right of a party to waive a claim would trump anything else. I don't know if the federal law could do that.
But there's no question that, as a matter of fact, there is no such agreement, whether you call it a release or a waiver, as part of the Tim Cole Act compensation process and documentation.
I think the acceptance of the money is your acceptance of the terms of the money.
Yes, but as a matter of just a writing to evidence what the transaction, what the nature of the transaction is. In private litigation, you would have a release. There is no such aspect of the Tim Cole Act documentation.
Well,
Just
but in private, you can have an understanding, even an oral agreement, and you can use someone's acceptance of money in a private agreement as evidence of what parties intended.
Any other questions? Thank you, counsel. We'll hear from the state.
May it please the court. I would like to, in my 5 minutes, start by addressing some of the things that my friend on the other side said, and hopefully I'll have enough time to talk about the Supremacy Clause issue and the issue about settlement as well. The fatal flaw in Mr. Brown's argument is that it does not consider the statutory context of the phrase "may not bring any action." We know that the general rule that this court has provided the bar is that the court is going to enforce the plain meaning of the statutory text informed by the context. And the problem with our friends on the other side is that they're just focused on the meaning of this undefined term "bring" without considering the context of the statute. And in our brief at pages 9 through 12, we provide 3 pieces of statutory context that we believe supports our definition of the word "bring" and the phrase "may not bring an action" in the statute. Quickly, those pieces of statutory context are other provisions in the Act or provisions that are surrounding Section 153. It is also the title of Section 153, and it's also the statutory history of Section 153. So when you consider those 3 things, that supports the state and the county and the city's reading of the statute. So let me first start with other provisions. In our brief, we focus on Section 103.051E, which uses a similar phrase to 153. In 051E, it talks about a person who has their application for compensation denied may bring an action for mandamus relief. Now, if we accept our friends on the other side's definition, they would say that just means, using their definition, that would just mean you could file a petition for a writ of mandamus. But that phrase doesn't just mean you may file a petition. It means that you may have an original proceeding and prosecute that original proceeding all the way to its conclusion.
Wouldn't that be true if it just said you may file a petition for writ of mandamus, though?
Well, I think that's supporting our position, because what we're saying is it doesn't just mean file, it includes everything, inception to conclusion. And they're saying it just means filing a pleading. And so the other thing I want to mention, 5 minutes goes quick. The other thing I want to mention is that, and this isn't on our brief, but there are at least 8 other provisions in the Tim Cole Act that use the word file when the legislature is referring to the commencement or initiation of an administrative proceeding or other process. So quickly, let me turn to the title of Section 1153. And we recognize that a title of a section cannot enlarge or limit the meaning of the words in that section. But it, again, is informative of what the legislature was thinking. And the title of 153 is Employees Not Liable After the Payment of Compensation. Now, if we go with the version of bring that our friends on the other side use, the legislature would have written a title that said something like, employees may not be sued after payment of compensation. But they didn't say that. They specifically used the word liability in the title, and liability, as we all know, comes at the end or during a proceeding. You're not liable when someone files a petition or a complaint and pays a filing fee. And in the context of that title and other provisions, what the legislature means by bring is it authorizes a suit.
If we're going to look at that title, does it mean anything that it says employees and not governmental units are not liable?
I think this would be speculation on my part. I don't have a good answer why they used employees and didn't say employees and governmental units. I take that.
Does the title kind of cut both ways, I guess is my question.
Well, I think maybe it didn't, it may cut both ways, but I think it leans more firmly in our direction, because they didn't say may not file an action or may not be sued. They said employees not liable. And I think, and that's what your footnote 60 in the Brown original proceeding in this court. In footnote 60, the court wrote that the administrative compensation applies when it's received, it excludes any other action. And I think that's indicative of what we're saying here. Once you receive that compensation, whether you filed the lawsuit before receiving it or you filed it after, it bars the compensation. And I would also just like to quickly mention the statutory history. When 153 came into existence, it came in with the former version of 101. And that was when there was a subchapter C that provided for a lawsuit. There was a bifurcated process. You could have an administrative proceeding or you could have a lawsuit. And in the former 101, when the legislature was talking about the commencement or initiation of a proceeding, they used those words, initiation and commencement. And when they were talking about someone having a suit, they said bring. So in subsection A of 101, it said a person may bring a suit against the state and sovereign immunity is waived. That is saying we authorize you to have a lawsuit. And then in subsection B, it said the way you initiate a lawsuit is by filing a verified petition. And the way that, and in subsection C, it had a venue provision, and it said the venue is either in the county of someone's residence where the suit was commenced or in Travis County. And I'm a little confused. Oh, it's red. I'm sorry.
I think we have your point.
Yeah.
Any other questions?
And I apologize I didn't get to the supremacy clause.
Thank you, Mr. Lineberger. Mr. Biles, I believe you have 5 minutes.
I have 5 minutes. I'm going to be very fast, try to answer all that was just said. First off, I agree absolutely with the city of Houston that in fact, as this court has pointed out, legislatures have to make balancing choices. And those balancing choices, as this court has pointed out, they can't always get everything they want. They have to make political decisions. They have to weigh those consequences, and that's for them to do and not the courts. And in this particular instance, what we have are two defendants standing up before this court saying, we don't like the bargain that they struck. We wanted it all. We wanted for us never to be liable. The legislature chose the words they chose, and they chose to not include the words they chose not to include. They made a balancing choice.
Let's talk for just a minute about the statutory history point that your friend from the Attorney General's office was just mentioning. Maybe I'll ask you this. The 2001 version of Chapter 103 specifically addressed, and this is changed from the 2009 amendments, but in 2001, when the section that we're concerned about was enacted, that version of the statute specifically addressed the situation in which you have pending lawsuits. And as I understand it, the choice then was continue on with your lawsuit, or now we're going to give you this administrative remedy and you can do that instead. Is that correct as of 2001?
Yes, and I planned on, that was the next thing I was going to get to.
Okay,
Because,
great. Well,
yeah.
so if that was correct as of 2001, and the provision, section 153 that's unchanged as of now, why would that statutory language have changed in meaning just because other provisions, we've gotten rid of the litigation option, now have exclusively administrative?
Because I think this proves exactly my point, which is the legislature knows darn well how to write this. In the prior versions, they wrote it to very specifically say you may not proceed under both. Just as like this court said in Oakley, we know that the logic of the argument being presented by defendants is not correct, which is that the legislature intended to prevent duplicative recoveries. And Oakley said, no, that's not true. They chose the words they did. That's not what happened. And in this one, they said, person who has brought a suit under this chapter, but whose suit has not been settled or finally adjudicated, may blah, blah, blah. So they specifically figured out how to write the words to make sure that you couldn't get both. And the other section says a person may not obtain compensation under both, there it is, may not obtain compensation under both Chapter 103, blah, 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 as it existed on this date. And so in other words, you couldn't sue under the old regime and get your administrative remedy. They laid it out in perfect English that made perfect sense.
Now they've gotten rid of lawsuits and they're thinking that it's just administrative. Doesn't that help potentially give some support to the other side?
No, because what they did is they got rid of lawsuits against the state. Under the original act, you had a choice. You could do an administrative remedy, or you could actually sue the state. The state not only waived sovereign immunity in the ill one, but it waived, immunity from suit. They waived both, immunity from suit and immunity from liability. So, and I need to talk about their three cases. I actually agree with all three of those cases. The last one of which actually helps us quite a bit, which is the one that they put in there, Sir Reply. That now I can't think of the name of it, but Dynamics. In Dynamics, the issue was it must be brought before a county of Harris County. A district court of Harris County. The court divided that out and said, what does this mean? The reason why it came out the way it did is because they said that removing the case to federal court violated the Forum Selection Clause because it brought the matter into federal court. It initiated a matter in federal court. It brought it under the jurisdiction. So it says to initiate a civil action under the jurisdiction of blah, blah, blah. So initiate a civil action comes from the word brought, and under the jurisdiction comes from before. So brought before, and so it's exactly the definition that I'm asking this court to apply. Bowles, they shouldn't be cited. Bowles is also a great case for us because what Bowles says, that statute, what it was left out is, or ordinance, whichever it was, it literally creates the cause of action. It says if this has happened to you, you are entitled to receive the greater of $50 or your actual damages trebled. You may bring an action to recover that. it's not context does matter. I agree. That's a very, very different context. That's literally creating the cause of action. And so it's a very different statute. CERNA, I happen to know quite a bit about this because I defend creditors. It's a FDCA, a Fair Debt Collection Practices Act. You can't go around suing debtors in counties in which they don't live or where the collateral is, right? And so in that case, the question was whether or not the court was going to have to enforce the statute against the defendant. They said, no, we don't have to. We don't have to because you didn't bring an action. You didn't bring an action because under the state of Texas law, to bring an action, you must file it and serve it. It didn't serve, so there's no damages. This debtor didn't get damaged because they never had to answer the lawsuit. They were never actually sued. I think I'm out of time.
Your time has expired, Mr. Wallace.
Thank
Any
you.
other questions? Thank you very much. The case is submitted. That concludes the arguments, and the case is set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.